welcome to Left, Right and Centre in a brand new week. I'm Nidhi Razdan. On the show this evening, the ex-law intern who claims she was sexually harassed by a Supreme Court judge has taken her case to the Apex Court, which will now hear it on Wednesday. As the outcry over alleged misconduct by judges grows, does the Supreme Court need to take a stronger stand against harassment by its own? Also later in the show, the political controversy over the Home Minister grows. His proposal to write to Chief Ministers on reviewing terror cases against minorities draws fire. Is his move unconstitutional, as the BJP alleges? But first tonight, a former law intern who has made sexual harassment allegations against Justice Swatantra Kumar today moved the Supreme Court seeking an inquiry against the retired judge who has rubbished all the charges. A bench headed by the Chief Justice has agreed to take up the case on the 15th of January. That's this Wednesday. The intern wants a proper inquiry.
Over 1 year after she was allegedly sexually harassed by a sitting judge of the Supreme Court, a lawyer has taken her battle to the Supreme Court. Not only has the girl, who was then an intern, asked the top court to probe her allegations against Justice Swatantra Kumar, now retired and the chairman of the National Green Tribunal, she also wants the court to set up a mechanism to deal with all such cases. Her plea follows an affidavit she had given to the Chief Justice of India in November, which was not acted upon.
This redress is a legal right. There is a larger prayer: establish a permanent mechanism across the country in all judicial bodies so that any complaint against a judicial officer can find redress.
While Justice Swatantra Kumar has himself dismissed the allegations as a conspiracy, several senior advocates and activists have come out in support of the young woman. They say it's time the top court walked the talk.
Court is going to really undermine its own dignity if it's going to depend upon media outrages to take up matters. There should be a committee that individuals can access.
The Supreme Court laid down the landmark Vishakha guidelines on sexual harassment at the workplace back in 1997. But to the surprise of many, the court only recently set up a committee to probe such cases taking place within its premises. And legal experts say the definition of workplace laid down by the Supreme Court does not adhere to its own guidelines. Now all eyes will be on the top court when it takes up the former law intern's petition on Wednesday. In New Delhi, Neha Khanna for NDTV.
So does the Supreme Court need to take a stronger stand when it comes to the issue of sexual harassment allegations against its own? That's our subject of debate tonight. Joining us on the program this evening, we've got Vrinda Grover. She is the lawyer for the former law intern in this case who has petitioned the top court today. We have also with us senior lawyer Raju Ramachandran joining us tonight. Senior advocate Sanjay Hegde joins us here in the studio, and author and columnist Tavleen Singh joins us this evening from Mumbai. Vrinda, let me ask you first. What Justice Ganguly's case and this case have exposed is the lack of an institutional mechanism to deal with these issues and to deal with these allegations. And is that at the heart of what this young woman is saying to the Supreme Court today?
You're absolutely right, Nidhi. Because if there had been institutional mechanisms available since 1997, when Vishakha mandated that every institution in the country, which includes the courts of the country and the Supreme Court of India, must have in-house mechanisms to address and redress complaints of sexual harassment, because this is the way we will prevent sexual harassment and create workplaces where women can work without fear. However, we have seen that since 1997 onwards, the courts have not complied with their own mandate. And even today, actually, the notification and the new committee that has been formed only recently in 2013 does not have jurisdiction over judges. Both the first intern and the second intern had no fora to present their complaint. So when we are hearing all this about, oh, there's a delay of so many years, where should she have gone with her complaint? She is seeking an acknowledgement and a validation of the truth of her allegations. The law says that will be an in-house mechanism available. When she saw that the Supreme Court responded very positively and provided some redress, some forum to the first intern, she too sent her affidavit to the Chief Justice of India on 2nd December 2013. It is regrettable that it was returned with the full court resolution, which we have now challenged, among other things. All that we are seeking even now, please establish a forum where any allegation of sexual harassment by a judicial officer, including a judge of the Supreme Court of India, and to my mind, this is a more serious case. He was at that time a sitting judge of the Supreme Court of India, and she was an official intern working for him officially.
Okay, Mr. Hegde, Many would say then that this is a morality crisis for the Supreme Court, and this is a test case for the court to see that if it can stand up and put in place credible mechanisms. Would you say that at the very least, that is the very least the court should do?
I am nobody to advise the court. I'm just nobody. I mean, it's open to my friends out here to first file petitions in the court, but even before they file petitions, to come on the media, conduct a trial by television. I mean, that's just not on. The normal rule for all lawyers, irrespective of whether you're male or female, is that if you are involved in a case, if you're going to agitate it in a court, you do not try it in the media in advance. Maybe we have moved on in morality, maybe. I have nothing to say on that. But let's take the question of what does the court do as policy. The court has taken an administrative decision. All the judges took an administrative decision on the same day that they let out the report on Justice Ganguly, that in future, no complaints about retired judges, about anything. It's not only limited to sexual harassment. Let's say there is a complaint that a former judge is not paying a servant. Let's say there are so many situations.
The allegation is about the judge when he was in office.
Listen to me. There would be, when a judge retires, he goes back into private life.
But
he
this
is an
didn't happen
ordinary
when he was
citizen.
Retired. This did not
he is
happen
an ordinary
allegedly.
Citizen.
This allegedly did not happen when he was retired.
Nidhi,
right?
can I
I'm asking
finish?
you a question. Yes.
Can I finish? He is an ordinary citizen. He has no immunity. He is subject to the same ordinary process, and the same ordinary process applies also to the accuser. The ordinary process is go to a police station, file an FIR, and thereafter let the process of law take over.
Do you know what the Vishakha guidelines say? You don't have to file an FIR.
No,
you don't have to.
No,
there are
please,
other. There is another recourse
Vishakha.
open.
Now let's get to Vishakha. Vishakha provides a mechanism which provides for a safe working place. It is the moment there is a criminal act, then Vishakha gets out, and the employer can. The employer can say, okay, go to the normal procedure. As far Vishakha continues, so far as the employment continues. Once the employment is terminated, there is no more Vishakha.
Let me ask you, tomorrow, if an allegation was made against a sitting judge right now,
yes,
doesn't it disturb you just a little bit that there is no mechanism to deal with it within the court as an institution?
No, that I agree. From today onwards, or from whenever the Supreme Court took those guidelines, insofar as any judge who is at that point of time sitting, there should be a mechanism. But let me also
tell you, you're saying it shouldn't be retrospective.
It shouldn't be retrospective. And let me also tell you something else. There is Article 121 of the Constitution. Article 121 of the Constitution says that you will not discuss a judge's conduct even in Parliament except when there is an impeachment motion.
Why not?
Very good question. Why not?
Yeah.
Because the Constitution makers placed great importance on the independence of the judiciary. You kept them under a protective immunity. You sought, the Constitution makers valued
to conduct judicial work, not for misconduct.
Exactly.
That is not whatever. Law does not give you immunity to have misconduct. Nobody.
Or to
please understand, as a lawyer, it is our duty. It is not that we cannot question. It is an administrative decision of the Supreme Court, the full court resolution of 5th December. It has been challenged in a judicial capacity. The Supreme Court can sit over its own administrative decision in a judicial capacity. This petition is very much within the four walls of the law. It is my duty as a lawyer to make sure that the fundamental rights of all people in the country, including women lawyers, law interns, are safeguarded. I have for the first time heard this completely bizarre interpretation of Vishakha. That is not the manner in which Vishakha has since 1997 onwards been either implemented, or even interpreted by the High Courts and the Supreme Court of this country.
No,
so let's
put
that aside. Let's put that aside. So now we are here. The reason why we have independence of judiciary.
Judges the reason who are 90 years old today. There are judges who are 90 years old today. If we go by that logic, we will have to go retrospectively right back. This is the logic of the Constitution of India, not my logic. The Constitution of India safeguards the dignity of women. Interpretation which a particular section of the bar has now taken to absurd levels.
It is the court. We have moved the Supreme Court. We are asking for process. If you move the Supreme Court, you argue in the Supreme Court, not in the media. And nobody is arguing.
Nobody
is arguing in the media.
Either you give up the brief in the Supreme Court, or you argue it here.
What I shall do or not do, I shall determine on my own. I don't think I take instructions from Mr. Hegde at all. Let me put my viewpoint. If that is disturbing him, that really he has to deal with that separately. Let us understand what is the law, and so are we saying that immunity is provided so that the judicial function is discharged without fear of favor. Immunity is not to shield
let me get Raju Ramachandran here.
Particularly sexual
Mr.
misconduct.
Ramachandran, on this issue of a media trial, now there are two parts to it. One is that, do you necessarily see these issues as becoming a trial by media? Or is part of the problem that we have such a halo over our judiciary and our higher judiciary in particular that nobody wants to debate the problems, the issues of corruption and misconduct, and now it's coming out into the open because this country is outraged about sexual violence against women? Or is there some truth in what Mr. Hegde is saying that, you know, anyone can level an allegation today against anybody. The media can go to town with it. How do you protect that person's reputation if in the end it is proved that the allegations are not true? These are just valid questions. I'm asking you, Mr. Ramachandran, what do you think?
Nidhi, if a complaint is filed before the Supreme Court, as in this case, and the contents of that complaint are revealed because the Supreme Court decides not to take cognizance of the complaint, and someone then decides to challenge the refusal of the Supreme Court to entertain the complaint by filing a petition, this is bound to come into the public domain. Yes. And only through the media. I don't see any media trial at all here. I disagree with Mr. Sanjay Hegde on his proposition that a judge's conduct can never be discussed. This has nothing to do with his judicial conduct. Going by Mr. Hegde's logic, if a judge is corrupt, you can't discuss judicial corruption. Surely that was not the intention of Article 121 at all. And you are right that this halo around judges is what is responsible for so many things not having come out in the public domain. And I'm not talking about the facts of this particular case at all. The intern has filed a petition. The court will need to take a decision on constituting a committee, and I believe the court ought to, because I think the full court decision was clearly wrong, to shut out complaints against retired judges. I can understand the court saying that against retired judges, complaints will be entertained only within, let's say, 6 months after their retirement. But to say that we will not look into complaints at all, for instance, if a judge indulges in an act of misconduct 2 months before his retirement, after all, the victim would take a little time to decide whether to file a complaint or not, and in the meantime the judge retires. That can't be the position.
But Mr. Ramachandran, what happens if the judge has retired, like in Justice Ganguly's case, that he was already a retired judge, and as Mr. Hegde rightly points out, he's then a private citizen, he's a free citizen, he's not part of the judiciary anymore. What happens if there is misconduct when the retirement has taken place? How does the Supreme Court then intervene on those matters?
Now, take Justice Ganguly's case. Of course, the court didn't have jurisdiction in the matter. But Justice Ganguly went before that committee. He went before that committee, questioned their jurisdiction, and also gave his version, hoping that his peers would clear him. Unfortunately, they did their duty. They looked at the facts and gave a prima facie finding. Now, just imagine if the opposite had taken place and that same committee had decided that the complaint was untrue. Then Justice Ganguly would have said the Supreme Court has exonerated me. You need a forum where you can place your grievance, and the person against whom the accusation is made also needs a forum where he can clear himself. There can be false complaints also.
Yes.
It's in the interest of all concerned that there is a forum.
Let me get Tavleen Singh here. Tavleen, is there therefore then a very serious responsibility that the Supreme Court has upon itself today to judiciously address these issues, set up a proper mechanism to deal with this once and for all, and not run away from what is clearly a serious problem in the higher judiciary?
Well, we don't know whether it's a serious problem. It certainly seems as though in the history of the Supreme Court there have only been 2 cases of this kind. But certainly if they had a mechanism, it would have worked. You know, the girls who have made these complaints should have been able to go there and say what they felt about it. But, you know, I want to try and widen the picture. In my view, the most important reason for India's dysfunctionality as a country is that the justice system doesn't work very well. That the justice system takes forever for cases to be decided. And that there are too few judges, many too few judges. So, you know, we need to keep the majesty of the justice system intact as much as possible. And I just think that, you know, you could make complaints against judges all the time of all kinds, and that's very worrying.
But when you say, when you say keep the majesty of the justice system, the fact is, Tavleen, I'm sure you don't deny that there is corruption in the judiciary. It is a serious problem. We have been having arguments about how judges should be appointed, whether those appointments are transparent enough, because right now it's cloaked in this big veil of secrecy. There is this issue of sexual harassment, which if you speak to senior lawyers like Vrinda will tell you that it's much more rampant than we think it is. These are the cases that have come forward. What does protecting the majesty of the judiciary mean?
May I be heard there?
Let Tavleen Singh answer that.
We go through the process of impeaching a judge when he's guilty of misconduct. But I personally don't think that he should be tried on your television show.
Agreed.